Welcome to the SCORE Minnesota Chapter's presentation on choosing the right business type. An attorney weighs in. Today we have Sara Castro Potts, a managing attorney who's going to talk to you about the various business types. But before we get started, let's do a little housekeeping. What is SCORE? SCORE is a nationwide nonprofit organization that's supported by the U.S. Small Business Administration. SCORE is a nationwide nonprofit supported by the Small Business Administration, or SBA. SCORE provides small businesses with free, confidential business mentoring. With nearly 90 volunteers, the SCORE Minnesota chapter has served Manatee and Sarasota counties for nearly 50 years. I'm proud to say that our chapter has recently been recognized as a Diamond Chapter of Excellence for mid-sized markets, which is the highest award for any chapter. Since its founding in 1964, SCORE has assisted over 11 million clients. We can help you in all phases of business, whether you've just woken up with an idea and are thinking about researching it, or you have that idea and you've implemented it, you're opening your business, or you'd like to grow your business, or lastly, are you thinking about selling or closing it for whatever reason? We can help you in all phases. Go to our website, minnesota.score.org. There you can request a mentor. You can find other workshops or webinars that are coming up. You can locate podcasts, recordings of our previous webinars, or you can search our library of resources for other types of files. Lastly, I'd like to thank the SCORE Minnesota sponsors and community partners. These banks and partners are here to help you. We've built a relationship with them, and they can help you get your business started or expanded. Now, without further ado, I'd like to turn the presentation over to Sara. Welcome, Sara.
General education and guidance so that you have that understanding as a basis, but then you could speak with me or again any other attorney when you go to set up your entity, and you're going to be in a better position than if you try and do it yourself. So just take this information with that caveat that it's bordering on legal advice, but to get actual legal advice, you need to explain your situation to someone and have them provide you that specialized input. So when you're starting out and you want to choose an entity, or you've been doing business and you want to transition and formalize it and start using an entity, you might look at the different types that we have available under Florida law. And in your search, you might hear terms like S Corp, C Corp, disregarded entity. And one thing I want to clear up at the beginning is a common misconception. There's the issue of taxes, and then there's the issue of what entity type you use. So entity types are the ones listed on the right in blue, and then tax elections are listed in the left column in pink. And tax elections are something that you should discuss with your tax advisor. So your CPA, your accountant, some people have a specific tax attorney. They would deal with your tax election, and actually different entities could choose between different tax elections. So for example, an LLC can actually take any of these tax elections here. So what I'm discussing today is the legal entity aspect, not the tax side. And whenever you're thinking about these issues, you should try and separate those two things in your mind. So what are the Florida entities that you can choose from? There's a few other minor variations, but these are the primary ones. So a sole proprietorship, which we'll discuss, is not actually an entity. That's the default when you do business without forming an entity. We've got LLCs, corporations, and then various types of partnerships. So I'm going to run down each one. I'm going to give you the pros and cons and some basic factors. It's a little dry, so forgive me, but it's hard to jazz up business law too much. I try and use bright colors to help make it a little more interesting. But the first one is sole proprietorship. So in a sole proprietorship, that's just you doing business, and you're doing business in your own name. It's owned by one individual, no distinction between you and the business. So the pro is that it's simple. The con is, well, there's a few cons, but one of them is that if you want to use a business name, you have to file a fictitious name filing, a DBA, either that or you just have to use your legal name. You have no choice on how to be taxed. This will go on your individual taxes. And then the biggest con is no asset protection. So you have no protection from the business liabilities with regard to your personal individual assets. So that theme will come up a few times today. So I'll explain it briefly and sort of tell you what I mean. So when you think about doing business, you have to think about a few things. You will have your personal assets, so things you own, like you might have rental real property, or you might own a boat, or you might own a second vehicle, or, you know, general property that you own personally. And then you'll have personal liabilities, which is, you know, things such as credit card debt, mortgage debt. You know, if you get into an automobile accident and you end up being liable in some way for that, those are personal liabilities. On the business side, you have business liabilities and debts. That's pretty obvious. Things you contract for, or debts you incur on behalf of the business. Could also be something like a slip and fall that occurs on your business premises and then becomes a liability of the business. And then you have business assets on the right as well. And that would be things that you own for the business. So think of your equipment, your inventory, things like that. So when we talk about asset protection, what we talk about is keeping those things separate. And that way, if you have a liability arise on one side, it doesn't go to the other side. So with a sole proprietorship, they're not separate. Everything is intertwined. So what does that mean? So for example, your business liabilities and debts can come over and attack your personal assets. Now in Florida, there's certain exemptions from creditors for your personal assets. I'm not going to get into those in detail, but a famous one would be your homestead. So if something is your homestead, then a creditor cannot take that under the Florida Constitution. It's, you know, why OJ moved here and put all of his money into his homestead, famously. There's other things like one vehicle up to a certain amount of value, certain personal property up to $1,000, or if you don't have a homestead, up to $4,000. Those kinds of things are protected so that you're not left homeless and without property. But there are plenty of non-exempt assets that you'll want to protect. So non-wage income in your bank account, you know, a second vehicle, your vehicle, if it has equity of more than $1,000, you know, another piece of property that's not your homestead that you own, those are your personal assets. So when you have a sole proprietorship, those are not protected. So if your business doesn't go well, you incur too much debt, or you get a judgment against you for some sort of slip and fall or liability, they can attack your personal assets. And then vice versa, your business assets, if you're doing business in your individual name, are not going to be exempt unless they're already otherwise exempt under Florida law, like I just stated, under those reasons. So you have no protection, no separation, and that's why we're going to look at the different entities that you can form to get that protection. And it turns out there's a few that are relatively simple, not that difficult, and provide you peace of mind. So in sum, a sole proprietorship is simple, but it's not preferable. So the next one is a limited liability company. If you can just hold on for just 1 second. So Florida Limited Liability Company is an often preferred entity of choice for many people, and there's a few reasons for that we'll get into. One, you have quite a few tax election options with an LLC. You can choose to be taxed as a partnership, where it flows through to your individual tax return, as an S Corp or as a C Corp. Now, I said I wasn't going to discuss the tax side, and I'm not. It's always your tax advisor or your CPA that you go to discuss that. But just one basic thing is, at least with an LLC, you have those options, you have that flexibility, and then you work with your tax advisor to choose the right choice for you. With an LLC, you have protection of your individual assets from your business liabilities. Now, I will say that several times today. And you should always understand that that's with the caveat, as long as there's not a reason to pierce the veil, is what we call it legally. So there is a reason to pierce the veil under certain situations in Florida law, and I won't get into it in detail because we're limited on time, but essentially you can use that corporate shield for protection as long as you're not using it in a fraudulent manner. So you can't go around doing blatantly illegal or fraudulent things and then have that corporate shield protection. You lose that protection under those types of circumstances. So whenever I'm saying that a corporate shield protection applies, it's as long as you're doing everything in the normal and appropriate and proper way with your business, you get that protection. Vice versa, with an LLC, you get protection of the business assets from your own individual liability. So if I get in a car crash and God forbid I'm liable for some amount of money as a result, they are not going to be able to take the assets of the business again, unless there's some reason to pierce the veil, unless I'm not running the business as a true separate entity. And then finally, there's a distinction under Florida law that's become very important as a result of a case, a particular Supreme Court case, and then a statute that followed that case. And that's the distinction between multi-member and single-member LLCs. Multi-member LLCs are always preferable. In the case of a multi-member LLC, what I'm saying is there's multiple owners. So the name for an owner of an LLC is a member. So for a corporation, it's a shareholder or stockholder. For an LLC, it's a member. So when you have multiple members for an LLC, you have better protection, because in that case, by statute in Florida now, a judgment creditor of an owner of a multi-member LLC can only get a charging lien against your ownership interest. And what that means is all they can access are any profits that the company chooses to distribute to you. So you might choose not to distribute profits in that type of situation, and that gives you some control, and they cannot do anything further. If you have a single member LLC, you get some protection, but it's not as good. Under the statute and the case law, in that situation, if the judgment creditor is able to show that their judgment will not be paid within a reasonable time, then the court can order that your membership interest is foreclosed. And that means like sold at a foreclosure sale, just like a house. So that's why it's always better to have a multi-member LLC. That's the best level of asset protection. But a single member LLC is still better than a sole proprietorship. Corporate formalities are very easy to maintain for a limited liability company. You're not required to have annual owner meetings or manager meetings, although it's probably recommended to have some. And the other formalities are basic. You just keep your assets separate, maintain separate bank accounts, operate it as a separate business, and don't dip into it as your personal piggy bank. Just sort of keep the basic formalities in place, and you would be good under the LLC statute. There's some record keeping requirements and other things like that, but essentially your corporate veil isn't going to be pierced just because you were not the best at record keeping. It's cost effective. The filing fee to Form 1 is $125 with the Department of State, and then it's $138.75 annually to maintain it. So it's quite cost effective. That doesn't include attorney's fees. If you are hiring an attorney to draft you your documents with regard to it. But this is just looking at the Department of State fees. It's quite affordable. And on the attorney side, it's usually not too bad either. It's more marketable than a sole proprietorship. You're more easily going to be able to sell your company if you have separated your assets into a company, into an entity, than if you are just running your sole proprietorship. under your individual name. So say when it comes time to retire or otherwise sell, it's going to be easier. And it's easier to obtain financing if you have an entity with a history than if you are doing business as a sole proprietor. So overall, LLCs, good asset protection, easy to maintain, cost effective, they're marketable, good for financing. Only con is not as simple as a sole proprietorship, but the pros far outweigh the con on this one. So I do recommend LLCs. Looking at another entity type, a corporation. So for a corporation, you can choose to be taxed as an S Corp or a C Corp. So you do have some choices, just not as many. You do get protection of your individual assets from your business liabilities. So you do get that corporate shield protection. The business assets are protected from your individual liabilities. The one thing that you don't get here that you do get with an LLC is you don't get protection of your ownership interest in the corporation from your individual liabilities. And what I mean by that is your ownership in a corporation is represented by shares of stock. So those shares are what we call intangible personal property, subject to levy and execution. And what I mean is if a judgment creditor gets a judgment against you, they can levy and execute upon your property. They take your property to satisfy the money that you owe them. And stock is one of the things they can take. They cannot take ownership interest in a multi-member LLC. So that's a nice protection that an LLC has that a corporation does not. The corporate formalities are slightly more. For a corporation, you're required to hold annual director meetings, annual shareholder meetings, and there's some other formalities in the statute that apply. So there are a little more formal steps to maintain your entity with a corporation than with an LLC. It's a little less simple. And the filing fee is not bad on corporations, $70 to begin and $150 annually. So it's also not too bad on the fees. Again, more marketable than a sole proprietorship. When it comes time to sell, it's good to have your business in an entity. Also good for obtaining financing versus a sole proprietorship. So in summary, it is a good entity to use. Usually I would lean towards an LLC just because it's easier to maintain and just because you also get that protection where your ownership in the LLC is not subject to levy and execution for your individual liabilities. But sometimes there are reasons to go with a corporation. It's usually something from your tax advisor or a tax perspective, or maybe you see growth in your future where you eventually want to go public or something like that. There could be more complicated reasons, but for most small business owners, you usually lean towards an LLC. A general partnership is another entity. So this is sort of like a sole proprietorship for more than one person. So if you just start doing business with a friend, you are operating a general partnership. You don't have to file anything. It just happens legally. So good thing is you don't have to file anything. It also passes through to your individual tax returns, and every person in the business can act on behalf of the business. Well, while that's simple, that's also a bad thing because you are liable, fully liable for everything that the business does. So if your business partner goes and does things that are not advisable, that you don't agree with, or that end up incurring too much debt, you are fully liable. And what I mean by that is it's joint and several liability. So if your business partner doesn't have the funds individually to pay for that debt when it comes collection time, a creditor can go after you for the total amount. They don't have to do it half and half or include your partner. They can go after whoever is the easiest target or whoever's the most collectible. So, you would have to really trust the person that you're doing business with. And regardless, it's not a good idea because you don't get any asset protection. And there are other ways to do business in which you do get asset protection. So you don't have any other tax election choices. It's not very marketable. It's not good for obtaining financing. And bottom line, just don't do it. They're not a good idea. If you go into business with a friend, a colleague or an acquaintance just form an entity and do it that way, it's going to be less money up front than dealing with possible trouble down the line, and you'll be more protected from the outset. A limited partnership, these are also not favorable now under current law. A limited partnership is a different type of partnership. You have to have at least one general partner and one limited partner. The general partner has authority to act on behalf of the business, and they are also fully individually liable for all of the debts and obligations of the business. So that's not a good thing for the general partner. The limited partner can limit their liability, but they also don't have any control with regard to the business, or limited control. It's passed through taxation to your individual tax returns. The filing fee is expensive. It's almost $1,000 and then $500 annually. And given that it's not a preferable entity, then we don't want to go this way, because the general partners have no liability shield at all. And the way that the law has developed, there are better entities out there now. So some people file for a limited partnership thinking that they are forming a different entity and they have protection, when they really don't. So you have to beware, because these are still allowed under law. You can still form them. But when you do, you're not giving yourself any protection if you are the general partner. So these are not preferable. This is one of the newer types of entities that has evolved to provide some protection. So this is a limited liability partnership. So these acronyms get really confusing, and the different types of partnerships get really confusing. But the way to think about this is you can convert a general partnership to a limited liability partnership. And then what that turns into is it turns into a general partnership where every partner is a limited partner and they don't have individual liability. So this is a viable alternative to a general partnership. The fees are low because you just file a statement of qualification to change yourself into a limited liability partnership. And this is where some people make the mistake, because they think they have this, but they haven't properly filed that statement. And then they haven't limited their liability by doing that. So this is preferable to a general partnership, and it's similar in the way that it's run. Finally, we have a limited liability, limited partnership. And now you see why I said that the names and the acronyms get confusing. This is a useful entity under certain circumstances. This is like a limited partnership where there's some general partners and some limited partners. But the good thing about it is that corporate shield of protection has been enlarged to include all of them. So both the general partners and the limited partners are all protected. Now you might be saying, why go with this, or why go with an LLC? How do I choose between them? Some things that might weigh on your choices are you don't have any different tax election choices with an LLLP or triple LP, a limited liability, limited partnership. So that tax flexibility sometimes leans you towards an LLC. The statutory requirements are more costly. The filing fee is $1,000 and it's $500 annually. And that's a limited liability, limited partnership in a nutshell. There are certain times when it's useful and appropriate, though. So looking back, these are the entities that I did not nix, that I did not say you should not use. So this is sort of a summary to help you get an idea of how to compare those entities. So the first thing we discussed, corporate veil protection for the owners. That is here in all of them. So you get that in all of them, unless you start acting fraudulently or something like that. One example of a situation in which the corporate veil would be pierced would be if you transfer your assets from one entity to another entity to try and avoid a liability. So I do litigation as well as business law, and I've seen this in certain situations where somebody will have a large judgment come up and they know that it is going to be something that will be so problematic that it will bankrupt their business. And though they said they have this bright idea, well, why don't I just form another entity, have an asset sale, move everything from one entity to the other entity, leave the liabilities behind, and I'm free and clear. Well, if it's a genuine asset sale where it's two arm's length people, and that means it's two people that aren't involved, aren't the same people, it's a true commercial arm's length transaction, you can have an asset sale where you leave the liabilities behind. But you can't do that if you are doing it just to avoid the liabilities of the prior business, and that's your sole reason for shifting over the assets. So in that situation, you're going to have your corporate veil pierced. That's an example. And there's others, but they all basically involve fraudulent behavior. So if you are wondering about it, as long as you are running everything by the book, you're probably going to know if you enter the arena here. It's probably akin to that sort of, if it feels bad, you're probably doing something that is borderline, then you're probably entering that arena. And that's when you want to get some legal advice and make sure you're not doing something that's going to destroy the protection. That's the whole reason that you have formed an entity. Here, the second column, you'll see this is where we start to differentiate, and some entities start to be better than others. So that's protection for the entity from the liabilities of the owners. And that's unless there's any reverse piercing done. I won't bore you with that. But here we can see that multi-member LLCs are good. The most that a judgment creditor of an owner can get is a charging order on distributions of profit. So it's essentially a lien on any profit that you distribute. The same is true with regard to the limited liability partnership and the limited liability limited partnership. You do not get that protection in a single member LLC or a corporation. You can see a single member LLC is slightly better than a corporation because they will be limited to a charging order unless they can show that the judgment will not be satisfied in a reasonable time. But in a corporation, they don't even have to make that type of showing. They can just take your stock in your corporation to satisfy your individual liability, which would be worst case scenario. You don't want to spend a good amount of your life building a successful, thriving business and then have some unexpected liability come up and lose your business that way. I can say that with regard to judgment creditors, one good thing to know is that often closely held companies, we call them, which are, small companies where the owner is probably a key employee or a key person in the success of the company. Those aren't always attractive businesses for a judgment creditor to take because they realize that once they take that from that owner and that owner is no longer participating in the management and running the company, it really loses its value. And especially without their cooperation to make any sort of transition. So it's not always attractive to judgment creditors, but it's good to give yourself that protection if you can. Let's see, the filing fees, they're all pretty similar unless you get into the triple LPs, then you're looking at the higher fee of $1,500 annually. And then with regard to the complexity of management, LLCs are more simple. You get more complex as you get into the partnerships and the corporation. So it's another reason to lean LLC, unless you really have a complicated asset plan or a complicated business plan that warrants that expense at the outset. What you have to consider is with the expense, you're not just talking the filing fees that I've discussed here, but if you're doing this the right way, you're probably going to be talking about the attorney's fees. So you can go to many business attorneys and get a operating agreement for an LLC drafted or bylaws for a corporation and a shareholders agreement. But with regard to a partnership, you're going to want to make sure that that's properly drafted, and that's often much more expensive. So for example, we could be looking at a difference of approximately, say, $950 for an LLC, whereas if you're looking at a partnership, you might be looking at anywhere between $5,000 to $15,000 and up to have everything structured properly. So you're not thinking just about filing fees, you're thinking about attorney's fees too. And if there's a real benefit there to justify that. One thing that's useful to know with regard to management of LLCs is in Florida, we used to have a concept called member managed or managing members for the LLCs. We don't have that concept anymore, even though you'll see a lot of people will file that way, because you still can file that way. But the concept doesn't exist anymore under Florida law. Instead, we simply have either member managed LLCs or manager managed LLCs. Now, member managed LLCs are where the members, the owners, manage the LLC. The other option is manager managed LLCs. Most people lean towards manager managed LLCs because it provides you some more flexibility. That way you're separating management from ownership. So you can have ownership and then you can make changes in management without making changes in ownership. And you can have, for example, two owners, but only one of them is going to be in the business doing the day-to-day operations and running the business. Then that person is most likely going to be appointed to be the manager. And then that makes it simple because only one person is making decisions, controlling things. You don't have to have a vote and they have control. And you can also even hire a manager or have someone be the manager who is not an owner. So if the owners want to own the LLC, profit from the business, but not manage it, you can appoint somebody who is not an owner to be a manager. The only thing that you'll want to ensure you understand is there's a distinction. It's not just like I walk into CVS and I ask for the manager. The manager, with regard to the legal meaning, under the Florida statutes, means more than that. They're going to have almost full authority on behalf of the company unless you restrict it in the operating agreement. And most of the time you can restrict it in the operating agreement, but as a matter of fact, if you walk into a bank, what they do is they'll pull up the entity on Sunbiz and they'll look and they'll see, oh, you're the manager, okay, your name's here, and they'll let you sign for a bank account or make changes. And a lot of times institutions will just go by what's on Sunbiz. And that's why you want to make sure that whoever you make your manager is someone that you really trust. And if you limit their authority in the operating agreement, you still want to keep an eye on the business, keep an eye on the bank accounts, and make sure things are being done properly, because even if they are limited, sometimes just as a practical matter, they can do more than they should, because banks and other businesses will just look at Sunbiz, confirm they're the manager, and then assume that they have the authority. So finally, you have more tax flexibility with a multi-member LLC or a single member LLC. With a corporation, you can be an S Corp or a C Corp. C Corp is the double taxation that you hear about. And then with a partnership, you don't have that flexibility. The other way that you can do this is if you do have a complicated business plan or asset plan, oftentimes you'll have an entity that is set up and then has other entities as the owners to provide a double shield of protection, and often for tax reasons. But that gets into the arena where it's very fact specific, and you'll want your attorney talking to your tax advisor so that everybody's on the same page and everybody's looking out for your best interests legally and tax-wise. So like I've said a few times today, always consult with your tax advisor when you're making these decisions. And I even like to bring in your estate planner Some people don't have an estate plan set up. We all get busy. It's very understandable. But there comes a point when hopefully you do manage to get around to having a trust put in place or having a will put in place. And what you'll want to do is make sure that the attorney that you have setting up your entity consults with your estate planner, and everything is tied in nicely so it all works well together. Oftentimes you could hold your interest in your entity in your trust, and that way, if you have a trust for the general purpose of avoiding probate, that aligns well, and you don't have to your family wouldn't have to open a whole probate court proceeding just to be able to pass along your ownership in the entity, because it can pass through the trust instead. So there's different ways where your advisors can work in conjunction with each other to really optimize the benefits that you get from that. So as I stated before, I do a variety of law. So I do the corporate and the business side, but I also do lawsuits and disputes. And I also do personal injury and then defective drugs and medical devices. And the reason that I mention this is it's very useful to be able to see both sides, because I get to see the transactional side. So people coming in, starting up their businesses. I'll stop my screen share now. Hold on one second. Starting up their businesses, starting their entities, and then I get to see them grow, and then someone might get to retirement and be able to sell and make a nice profit, and then I also get to see the other side where after the business sale, maybe we have a dispute on what the true purchase price was, what was really sold, things like that. So seeing both sides helps you make sure that you account for the different possible disputes in the documentation. And then when you are dealing with the disputes, it helps you understand the meaning of the documentation that you're arguing about. And a lot of times here, it's a case of being proactive, because you can avoid disputes. Usually in the beginning, everybody is on the same page. We're happy. We're going into business together. It's the best time to talk about, well, what do we do if this comes up? What do we do if somebody passes away? What do we do if somebody becomes incapacitated? What do we do if someone gets a good offer to buy their interest in the business? What's that procedure? Do we have rights of first refusals? Are we going to have a non-compete? Those kinds of things. It's always best to talk about that and come to an agreement when you're on good terms and you're friendly, because then when that event occurs, everybody goes, oh, well, we already talked about this. We decided it. We just look to the documents, we walk through, we follow the documents. And that's a lot better than the event already having occurred. And then everybody saying, well, no, I want this to happen and I want this to happen. And you haven't talked about it yet. And when it's real and it's not just a possibility, passions get inflamed, and it's a lot harder to handle after the fact. So that's why you can save a lot of money being proactive and doing it right, documenting it from the beginning. It might cost you a few hundred or a few $1,000s, but litigation or disputes on the back end can cost you tens of thousands or hundreds of thousands. And you can lose what you've built. So it can be a pain, and it can be difficult with dealing with life in general, but it's often worth it, whether it's me or any other attorney. And that's all.
That's all she said. Well, we have some great questions. That was a fabulous presentation. Thank you. I know that it's a very difficult subject to make interesting, but it's a reality, and I think everybody is prepared for that. So we have a couple of questions. One I think is a simple one. Of course, you may differ on this, but so if you started your company and as a sole proprietor and you want to switch over to an LLC, is that difficult?
No, you can do that. It's going to be a case of a lot of practical aspects. You'll be needing to change the name of your accounts and things like that. And you want to make sure you properly transfer assets into the LLC to make sure that everything makes it from your individual name into the LLC. So, for example, say that you your name was Diane and you started doing business as a sole proprietor, and you had a fictitious name, a DBA, and you had Diane's Flowers. So you'd want to make sure that you assigned Diane's Flowers into the LLC, the goodwill associated with it, that you changed your bank account, that you put the new EIN on your bank account. So that there's a few practical things. It might be a little bit of a pain, but in the long run, if you plan to continue to run a successful business or grow your business, it's worth it.
Here's one that popped up. What's better for a husband and wife in forming a tax prep business, an LLC or an LLP partnership? Now, is that a specific question that you might?
Yeah, it really depends. I'd sort of have to talk to you individually, me or another attorney, and find out some more things from you to really get the right choice for you. The main things I'd point you back to were the things that we talked about today. And the good thing is if you are doing a tax prep business, you might already have some of the knowledge on the tax side yourself. So that's helpful. But I'd say it's going to be more common to be an LLC. I can say that generally.
Okay, here's one. Can you explain the use of 250 article of agreement when its use is recommended?
I can't. I'm sorry.
That's all right. I had never heard of a 250 article of agreement. Is it required to have a partner's agreement if I select LLC with multiple members?
So what you're talking about would be the operating agreement, and it's not required, but it's very beneficial. So for each entity, for an LLC, it's called an operating agreement. For a corporation, it's called a shareholders agreement, and the bylaws. They're two separate documents for a corporation. And for a partnership, it's the partnership agreement. So for an LLC, you should definitely have an operating agreement. It's one of the most important documents. And it's where you would put all those things I talked about, like a right of first refusal if someone tries to sell or passes away, and what the manager can do, what the manager can't do. So having an operating agreement is highly advisable. There's plenty out there that are either free or low cost on the internet. The danger comes when you don't know what they mean, and then something does arise and you didn't realize what your rights were or what it was that you were signing and what it was that you were saying. So a lot of the people that I have come to me after the fact when something's gone south have an operating agreement like that, and we'll look through it to see what their rights are and what they can do, but it's not something that they thought about and were advised on ahead of time. So sometimes it works, but it's usually not ideal because it wasn't tailored for them, and they might not have understand the legal effect.
So Anonymous wants to know, are these rules just for Florida or the same across the US?
So that's a really good question. This is state law, so it's state specific. The one thing that's useful is Florida is based upon the Uniform Limited Liability Company Act. So there is a uniform act that is promulgated as a model for the states that they can choose to adopt. And we are based on that model act, but we have some variations. So we have some things that were modified by our legislature and by our state Supreme Court. So it is state specific. I don't mess around with out-of-state LLCs, and out-of-state attorneys shouldn't mess around with Florida LLCs because there can be things that are state specific that you don't understand. So yeah, it's a good question.
Good answer too. Is a partnership only for two people or any number of partners?
Yeah, you can have more than two. So minimum two, but you can have more than two.
Good. What business structure would fit a digital monetized style for training and or counseling?
I'll give you the same answer as the tax advisor, that it probably would depend on having to have a more thorough conversation about your specific situation.
Right.
I hate to be a broken record, but LLCs are just easy, flexible, and affordable. So it's usually going to be LLC unless your tax advisor or your estate planner or them in conjunction with your business attorney advises otherwise, unless you've got a complicated set of assets or a complicated network of businesses that you run, you're probably going to be okay with an LLC.
So for multi-member LLCs, could spouses create a two-member LLC, or do we need to find a business partner outside our household?
So that's a really good question. And that's actually a sort of a gray area in the law. You can do a multi-member LLC with spouses, but there's a distinction there. So there is a form of ownership called tenants by the Entireties. And what that is it's a way that a lot of spouses own their home, even if they don't know it. And it's a legal fiction, and it's an entity sort of. And if you own your home, tenants by the entirety with your spouse, what happens by operation of law is if one of you passes away, the other one automatically becomes the full owner without needing to go through probate or wills or trusts or anything like that. So that's how that form of ownership works, tenants by the Entireties. So if husband and wife own something together in Florida, it's usually going to default to that form of ownership. So if you own an LLC, husband and wife, tenants by the Entireties, then there is a legal question, since it is that fictional joint form of ownership. Is that one owner or is that two? The courts haven't answered that with specificity yet, so it's a sort of a gray area. It's better than a single member LLC, most definitely. But if a family believes it is okay, generally for practical reasons, estate planning reasons, and tax reasons, sometimes they'll give 1% to a kid if there's any children available, or 5% to a child if there's any children available, or if there is another business partner or a key employee that you want to involve, give some small percentage, and then you've got that gold standard protection of a multi-member. But it's still, husband and wife is still better than pure single member.
Good. A few more questions. Another anonymous or the same. What if you started a company in Florida and then you moved? Well, firstly, why would you move from Florida? But if you moved to a different state, would you operate the same way?
So you can actually move your LLC with you, and we call that domesticating. So you can domesticate an LLC from another state into Florida, and most states will accept an LLC from Florida or an entity from Florida domesticated into their state. You can also convert your type of entity if you want to get really complicated. So you can move your entity with you. Some people don't for tax reasons. Maybe the other state has tax laws that apply, but your tax advisor might tell you, well, you might as well, because you're going to get dinged for tax anyway if you're operating here. So it's going to be a factual analysis of where your business is deemed to be operating, which in our cyber connected world can be complicated. So that was the long-winded answer.
So Lloyd would like to know, can you explain whether a B, as in boy, Corp requires another form of corporation first?
So I guess there's two types. I guess there's B Corp, and this is, I have to give a caveat. This is not something I'm extremely familiar with, but there's a B Corp under law, which is a benefits corporation, but then there's also a private certification for a B Corp. My understanding is that the private certification for the B Corp can be done with a different type of entity, like an LLC. But if you're going to do a benefits corporation under Florida law, like the entity type, then that has very specific requirements. And again, I'm not extremely familiar with that, but that's the way I understand it. Can you repeat the question? Because I'm not confident that I answered it.
I said I answered it. Let me bring that back up again.
Oh, requires, I see it. Can you explain whether B Corp
Can you?
requires another corporation for? No, you can, whatever you decide that you want to do, whether it's a benefits corporation within the meaning of the Florida statutes, or simply an entity that could be privately certified as a B Corp, you can do it all at the time that you form your entity. You don't have to do one first and then convert, but that you do have to make sure you meet the specific requirements, either under the statute or the private certification.
So Annabelle is asking, I'm not sure I understand this question, but if in Sunbiz they do not request ownership percentage, how will it be set up at an operation agreement?
Yeah, I get that question.
Oh, good.
This happens a lot. So your ownership doesn't go on Sunbiz. Don't put it there. A lot of people do that by accident when they do their own entities. Who the members are, who the owners are, that's private. And it's private for good reason. You want to keep that private from judgment creditors and from other people. So you put your managers on Sunbiz. If you have a member managed LLC, you might put your members on there. But since we lean manager managed LLC, you only put your managers on there. The ownership is detailed in the operating agreement. You can do certificates just like a corporation does stocks, but you don't have to. And more modern companies don't really certificate, we call that, aren't really having those hard copy certificates because it's just extra paperwork with no real benefit. And if you do need it, you can choose to certificate later. So your operating agreement is where you detail your ownership percentages and your ownership rights and responsibilities too. That's why that document is really very important. And you don't need it to form it with Sunbiz. So that's why a lot of people file their articles, they get their company going, and they don't realize they're missing a key document.
Do I need an operating agreement for a one-member LLC? Asks Rebecca.
The benefits to having an operating agreement for a single member LLC would just be the protections that you put in there for yourself from outside parties. So you can put some provisions in there that protect you in the event you have to file bankruptcy, or in the event that somebody, we call an assignee, somebody, in case they do foreclose on your ownership and take it, you can put limitations on their rights right in your operating agreement. So you can provide yourself some protections in the operating agreement. So you're not needing to outline your rights with regard to your partner, but you can outline your rights with regard to outside parties who might attack the LLC or have individual liability against you.
All right, I think this is the last question from Dee. Sure, somebody just posted one. Is B Corp available in Florida?
So if you're talking about the private certification, my understanding is it is.
Can any of these types be a nonprofit?
So a nonprofit is actually an entity I didn't cover, but a nonprofit corporation is under Chapter 617. So I discussed corporations under 607. Nonprofits are pretty similar, with the obvious exception that they are not for the purpose of a profit. And those are under Chapter 617. You have a board of directors, you have officers, and your most important thing as a nonprofit would be the tax side, where you make sure that you follow all the rules to remain tax exempt.
Very good. Well, that was the last question.
Okay. Well, I see one more, and it's do I hear a rooster?
That was yes, early on.
So my noise, I know that's a fun question, not a business question, but my mic background blocking isn't working so well, I guess. So I actually am remote today. So I have a Northport office and a Sarasota office, but today I'm remote at my home, and I live in an agricultural area. So we have roosters, and I can't always help it. My window's shut, but one of them happened to come right up to the windows.
Oh, funny. Oh, funny. I did hear it early on, and somebody did comment about it. Yes, there were a lot of comments about how small the slides were. I apologize for that, but you are going to get a copy of the slides. They will be emailed to you probably tomorrow, and as well as Rebecca has roosters too, as well as a copy of the video. So you'll be able to watch it again as well as look at the slides at the same time. So hopefully that will help for those who had difficulty seeing some of the slides. All right. Well, that was fabulous, Sarah. And I thank you so much for your time. We'll be contacting you again for further presentations. You did a very nice job, and we really appreciate the time that you dedicated to this. And I did put your contact information in the chat. If anyone is interested in contacting Sarah to discuss any of their business questions, she would be, I'm sure, more than happy to talk with you.
I'm always willing to have a chat with someone without charging, just to see whatever your legal issue is, business or not. I'll usually talk to you for 10 or 15 minutes for free and just sort of problem solve and see if I can help, because I had to hire lawyers before I was a lawyer. And I know how hard it can be, so I never mind doing that. And I really appreciate everyone sitting through it. I know it was dry, and I appreciate the opportunity to be here. So thank you.
Just as a wrap up, I'd like to encourage people to visit our SCORE Minnesota website at minnesota.score.org. Remember, you can even volunteer there if you'd like to be a mentor. We'd be happy to do that, to have you. If you want a mentor, you can apply for one. You can check out our other workshops, podcasts, or resources. Thank you for coming. You will be getting a survey. And if you could take a moment to fill in that survey, it would be great. Most importantly, what can we improve on our presentation, and what other topics are you interested in? So thank you very much. We really appreciate your coming. Bye-bye, everyone.